Welcome to today's video, where we'll be covering two cases. The first involves a Karen in Texas who managed to secure a favorable plea deal from the prosecution. However, there's one major issue: the judge is struggling to overlook her nearly 4 pages of criminal history, and she's finding it even harder to avoid being arrested in court for running her mouth. Before diving in, I'd like to thank today's sponsor, Chapter. Many people on Medicare end up spending hundreds or even thousands of dollars each year because they choose the wrong plan, often guided by brokers motivated by profit rather than genuine help. Chapter was founded after its creators saw their own parents fall victim to this system, and they decided to change it. When you call Chapter, you'll speak with a real person who will walk you through all available plans to find the one that's truly right for you. Best of all, the call is completely free. With Christmas around the corner and the average senior saving over $1,000 a year, now is the perfect time to put money back in your pocket. You can reach Chapter at the number on the screen or through the link in the description to have a real human review your options and ensure you're getting the best plan possible. Thanks again to Chapter for sponsoring this video. Now, let's get started.
Mr. Lewis, you have Crystal Vogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower.
No, I did.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, ma'am.
And any additions or corrections or?
There's a lot of history, we understand, Your Honor, but discussed it with counsel and also restitution.
Speak up, I'm sorry.
I just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
Nothing. I'm still continuing on my degree. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal history?
Yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
It's hard to believe that someone with this kind of background could obtain any sort of medical certification, especially considering her extensive criminal history and the fact that she's currently on probation.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, Your Honor, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the cars and that.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was no-
400 that was in the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified if I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the of another person, Your Honor, that's just one that's the charge. I'm not posting on there. But. She's responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called. Size, whether or not she has a comfortable. The backside, not to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same, like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
This is the last thing you want to hear from a judge reviewing your plea agreement, because even though the judge is considered a neutral party, they ultimately have the final say in determining whether a deal serves the best interests of justice. In this case, the judge isn't necessarily opposed to Karen receiving probation. Rather, the concern lies with the type of probation offered. She was granted deferred adjudication instead of straight probation, which would allow her, upon successful completion, to petition the court to have the conviction removed from her record entirely. Considering her lengthy criminal history, the judge is simply not comfortable.
I'm not. I can't. There's no way. I mean, it has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
If you overlook a few drug charges, some financial crimes, and even 5 human trafficking convictions, she might almost pass for a model citizen. Unfortunately, it's at this point that she manages to make her situation even worse for herself.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's on it.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You said you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too?
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Who's on me like that? You know, I don't want to do it. Like this. I'm not doing that.
I know, judge double negatives can be frustrating. With that, the hearing comes to an end, leaving me wondering whether her job will still be waiting for her as she tries to pull together $25,000 for bail. Now, let's shift gears and head to Florida, where we've got several hearings to cover in a case I've been following for quite some time. Next voice, next voice. I was thinking, that's exactly what Mr. First is saying. Did you not hear him? He can't give you his opinion. He's legally restricted from providing legal advice to you just as much as he's restricted.
Call Mr. McCoy's case.
Mr. McCoy?
Our conversations are included.
Mr. McCoy is here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time, these procedures, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request to have my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
If you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up a fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker, but however, you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark, can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my, the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about, I just want to know your opinion, sir, since you're the judge.
I can't give you my